Okay, because nowadays, before we start, Mr. Ng, why you think debt recovery is very important?
What I think is very important.
Why you think debt recovery is very important?
When you have debt against someone, you need to collect it from the other side, because I mean, of course, when debt occurs is either when you provide service to people or you sell goods to people, goods sold and delivered. So after the goods sold and delivered or service rendered, you have to collect the debt, because that's what you own and that's what you do for a living.
Can I say that is because debt means money, and we can't deny that money actually play a very important role in our life, especially in the current environment. We need a lot of money to survive. Can you say that?
Yeah, I believe Ms. Khoo, you could say that, because of course people doing business definitely want to gain something, gain profit, or at least recover the cost, at least. Or if the profits are negative, then the business must be suffering from losses. They are not earning anything.
Okay, let's start the live talk today. Okay, so I introduce myself first. I'm Miss Khoo here. I'm a lawyer and I'm practicing a law firm called Khoo. And Mr. Ng is my partner in the law firm. And both of us have done a lot of litigation cases in the court, and basically we are doing civil litigation, and Mr. Ng himself is doing some criminal litigation as well. Mr. Ng, do you want to introduce yourself before we go further?
Yeah, hi everyone. My name is Edward Ng. So I'm partner of Khoo, and then we're practicing mainly progressing in civil litigation, and of course we're doing family cases as well, a lot of family cases, debt recovery cases. Also, I think Ms. Khoo is doing currently doing some construction matter as well, and also some SIPA matter lah. So I believe that covers everything.
Okay. So today our topic is about debt recovery. So Mr. Ng, can you share with our audiences what is debt recovery?
Okay, I think this to put in the simple way. It is a process to recover, or we seek payment of debt from individuals, businesses, or perhaps companies, which we categorize debt and debtors in the event of them when they refuse or when they delay in paying us. So, I mean, in Malaysia, it's not uncommon for creditors to resort to legal action when all the attempts we have tried. We've tried all the attempts, you tried to get the payment from the debtor, but that debtor refuses to pay you. So normally, this is what means by debt recovery, I believe, Ms. Khoo.
And second question, Mr. I would like to ask you, why you think that the reason why you need to recover your debt? What are the main reasons?
I believe I have addressed the question with just now you have asked me. Of course, everyone in Malaysia is doing business for a living, and most of people are doing business for a living. And of course, we want to gain something out of it. Either people doing business or render service. Like us, we are professional, we are lawyers. We also render our legal service to our clients. So we are doing, of course, when we render the service or we are doing business, we want to get the profits. So if the business got no profit, or when we are unable to recover our costs, at least, then the business must be suffering from losses. And also, one important thing I want to pinpoint here, Ms. Khoo, is that every year the business owner has to submit tax application to Inland Revenue Board, income tax. So, assuming that the business owner will never try to recover the debt, so the sales that he made is considered as profit, but not bad debt in the context of taxation.
Understand. So basically, in short, because in business line, whatever sales you're doing is considered a profit for LHDN. So if you didn't even though you didn't get any profit, or you are not managed to recover your profit or the debt from the debtors, it will consider as a profit. Then you have to pay tax on it. Only when you start to commence the legal actions, then it will be considered not as a sales or the profit. You no need to pay tax for that. This is the main reason.
Yes, you're right.
Okay. Then Mr. Ng, what you should do to start a debt recovery proceedings?
I believe this is a question most of the clients will ask me. First, I would advise them prepare the documents which can show the debtor is owing money to you, such as purchase orders, delivery orders, and invoices, and a statement of account, and any other documents which they think can show the debt. So after that, bring the documents to see the lawyers. And normally what the lawyers will do is to help client to issue a document, a letter called letter of demand. And then the letter of demand means to inform the debtor to pay the debt or the arrear within prescribed time, normally 7 days or 14 days from the date of receipt of the said letter of demand. So of course, we must understand a point that it is not a mandatory requirement. It is not a mandatory requirement to issue a letter of demand, or we call it LOD, to the debtor before you even start your legal proceedings against the debtor. So, but it is always prudent to issue a letter to demand to your debtor, and it serves as a reasonable notice to the debtor that legal action will be taken. Should the debtor fail to pay accordingly, neglect, or refuse to pay, then thereafter we will commence legal action against them. And also, one point is that a letter of demand assists in building up evidence of indebtedness. So after that, then we can bring the legal action against the debtor by way of court action, which is what we normally do nowadays, especially nowadays when a lot of people are owing money due to the MCO. So a lot of people are owing money. So we are doing a lot of debt recovery cases nowadays.
I see. So I make a very short and simple conclusion. It means that before you want to bring a legal actions against the debtor, so it would be like appropriate or a suitable step is to engage the lawyers, then to help you to issue a letters. The letters is basically just to remind the debtors that okay, this creditor is intended to initiate a legal action against you. If you fail to pay the amount, the claim sum within a stipulated time. Am I right to say so, Mr. Ng?
Yeah. But that letter is not mandatory. You must bear in mind that the letter is not mandatory. Not to say that you must issue a letter first before you even can take legal action. There's no such a thing.
But it's just like a courtesy.
Yeah, we could say that.
Okay, this is a very interesting question. You see, a lot of my clients actually came to me where they would ask this question. Is there any a minimum amount owed before we can commence the legal action against the debtors? Because some of them they're thinking is that looks the debtors only owe me about 3,000. Is I cannot initiate an action in the court. Is that true?
I don't think it is true, but even regardless of how much being owed by the debtor to you, you could commence legal action against the party. But the only difference is that which court you should commence that legal action. So let's say, just give an example. If let's say the claim is up to 5,000, so normally individual will do it in a small claim court. They can do the procedure themselves if it is up to 5,000. But if it's more than 5,000 and until 100,000, that would be done in the magistrate courts. And normally a lawyer would be brought into the place. And if it's from 100,000 to 1 million, the matter will be conducted in the sessions court. And if more than 1 million, it will be in the high court.
I see. So basically, you see, it means that no matter how much money that the debtor owes to you, as long as you have a valid proof, you can actually initiate legal action. There's no issue at all. But just you have to initiate the legal actions in the correct forum, means that correct courts in the correct place.
The correct place.
You see, Mr. Ng, this is also a very interesting question. Some of my clients, after the debtors, right, they own money, maybe the debtor own he or she money more than 7 years or 8 years later, then they suddenly feel oh, I want to claim against the debtors. So the main question today is there a time limitation or the time limits to commence legal action against the debtors?
Okay, this is also a question that a lot of people ask me as well. So, in any matters relating to any forms of contract, the limitation period for commencing legal action is generally 6 years from the date on which the cause of action accrued, such as the date of the money is due for payment. So, if the party fails to take legal action within the time frame, which is within the 6 years, meaning that the party has waived the legal right against the debt. And also, if you bring the legal action against the other party after a time frame of 6 years, the other party could object by bringing in the issue of limitation.
Understand. That means that in short, if the debtors owe you money, please
Do
react
it soon as
and
possible.
do it
As soon as
as
possible.
soon as possible.
ASAP. Do it
Correct.
ASAP.
This is because, right, like example, if the debt is arise from the action from the contract, if you exceed 6 years only you want to take the action, basically the court will say you're out of time. Even you have a valid proof, you have a valid case, we can't argue, we can't have you argue in the court.
Yeah.
So whenever the debtor owes you the money, please do it as soon as possible.
And don't sit
If
on
you are
your-
right, you are right. Correct or not?
Yeah, but why are you waiting 6 years only? You go and recover the money. You see? So
You know what? You know what? I put in like this, Mr. Ng, because I have some clients whereby normally the relationship between the debtors and the creditor, they are friends. Most of the time they are friends or they know each other from the long time. So they were thinking that, look, if I take a legal action against the debtors, later he don't want to be friend with me, then how? It seems like not good. They will have this kind of even some personal feeling. That's why they don't want to take actions. But later on, when the creditor intended to get the money from the debtors don't want to pay. Even though they have money, they don't want to pay. By the time when the creditor want to take the action, it already exceeded 6 years. The time frame fixed by the law. That's the problem.
yeah, I believe also a lot of cases which I came across was those of them are having long time customer and clients relationship, so that they're constantly taking goods or constantly getting service from the other side, so that they are good friends, like what you say, Miss Khoo, so that the friends might just say, yeah, I'm having difficulty right now, can you please let me have more time, and then the matter is keep being dragged and after the period of 6 years. So a lot of times this kind of thing happens. So I mean, what I think, Miss Khoo, we should also inform our viewers here that don't wait lah, because if it's a matter of money, I think business is business, friend is friend. I think we have to separate these two issues, because why? You need the money for your survival. I mean, you need the money to pay your workers or your employees. So everybody needs that. Everybody is also facing difficulty nowadays. See? So
That's true.
my in a nutshell, do it as soon as possible. If you see got anybody owe you money, please demand the money from the other side as soon as possible. Do not wait.
My experience is that for those who are involved in trading, normally they will have some credit terms, like 30
Yeah.
days, 60 days, even up to 90 days. Some of the debtors, right, they can't take it even after exceeded like 90 days credit terms. But the creditor will choose to like keep silent and hoping that the debtor please and begging them to pay, but they still don't want to commence any legal action, but they're just waiting the debtors to pay. But turn up, right, the debtors run away,
Some is
create
like
a lot of troubles to them.
I drag the payment. Some of the cases I came across was like I drag the payment. I did not owe you, but the thinking was that I owe you. No, I drag the payment, but I do not owe you. So some like, okay, let's say, just giving an example, I owe you a money or amount of 100,000. I pay you 5,000 per month or I give you post-dated checks. So every month you could bank in the check to the banks. So, but this is also the way they do. But the problem is, if the check get bounced, or if the business having problem already shut down, or if the bank account already been shut down. So what's the problem? How? Well, that's a difficulty that they will be facing later.
That's true.
So a lot of times I ask them to seek to legal action and then demand the money in one shot. Do not wait.
I truly agree with Mr. Ng. You see, okay, the next thing is that some client they engage us, they will tell us, look, I don't want to take court action lah. If I take court action, right, I think we have to go to the court, I don't want to spend my time to go to the court. I have to work. I have to handle my business. I don't have time to go to the court. That's why I don't want to take court action. So, Mr. Ng, in your point of view, is that true that whenever the creditors, they want to take the court action, they must go to the court every single time?
I believe that Miss Khoo, you're also quite well aware of this matter. I mean, you know it quite well.
I let you to explain.
Yeah, because if this is a criminal matter, meaning that if a person is being charged in a court, then of course the person who is being charged has to be present in the court every time the case is being called. or a case having mentioned, but this is debt recovery is a civil matter. So this is a wrong perspective that among the public that after they commence a civil legal action to recover the debt, they have to personally go to court. This is wrong. They can appoint a lawyer to represent them. They don't have to personally go to court. See, the lawyer will attend every case management or hearing for them when there's a matter held in the court, and also the client attendance is not necessarily. So, I believe I also need take this opportunity to address another point is that which I always come across, Ms. Khoo, is that a lot of clients will ask how long the matter will take, whether it is fast or not. So my opinion to them is that when the debt is a straightforward matter, the person owe you money, you have all the documents in place, so the other person cannot deny that he or she doesn't owe you this money. So you have the sufficient documents and the sufficient evidence. Invoices have all been acknowledged and signed by them. So what the lawyer can do now, what we can help to do is now to file a summary judgment against the debtor and get the judgment fast. As the whole process perhaps is less than 2 months or less than 1.5 months. So the thing is fast. It's not that. Well, I feel that a lot of people nowadays got the perception that I go to court, or the case will postpone for 1 year or postpone for 2 years. It's very troublesome to go to court. I don't go lah. Especially the elderly people. So I say no. You have to understand those cases are criminal matters which last time. So of course, because last time, of course, we don't have all the equipments. And of course, courts also not having enough staff last time. But now it's different. Things have to run fast because we got KPI. Things have to run fast. So normally the things can be settled quite fast. We will file summary judgment, and then with all the evidence in place, the court may grant us the summary judgment so that that person doesn't have to be present in the court because to testify for the case, because the court has to grant the summary judgment. And we can proceed for enforcement straight away after that.
Understand. Okay, you see, I think I put in this way. Okay, normally client will ask. I go back to a little bit just now. The previous question is that if we take court action, that means that we personally have to attend the court action. Actually, right, we no need to personally attend the court action. Is because we normally the lawyer that you engage, right, will help you attend the court. They will attend on your behalf for every case management. Only if your case go to the trial stage, whereby you need to be called as a witness, then you only need to go to the court. But I'm sorry to say, normally debt recovery cases, if the kind is very straightforward type, whereby you have purchase order, delivery order, invoices, statement of account, whereby it's a very straightforward sales of goods, you not even have to go to the court. It's because, as what Mr. Ng say, you can actually apply a process called summary judgment, and it really take a very little time only to complete the whole thing. And to be honest, if you proceed for summary judgment, you no need to go to the court at all. But your lawyer, the lawyer that you appointed, need to go to the court on your behalf.
Yeah, the lawyer will go to the court for your case every time the matter is being caught in the court. So don't have to worry about that. And you yourself doesn't have to be present in the court for this. Okay, so no worry.
Yes. So, you see, this is another thing that the client would normally ask us. After I sue the fella don't have money to pay me, then how? I know the fella have money to pay me. For example, I get the judgment. He lost the matter. Okay, he lost the matter. I know he got money to pay me, but he refused to pay me. And I got the judgment. It's just a paper judgment. So what I can do to enforce the judgment?
What do you think, Ms. Khoo?
I let you to answer first because my answer is going to be damn long.
Okay. So our question is, I don't want a mere paper judgment. What can I do to enforce the judgment? Okay.
Correct.
Okay. You see, of course, there are a few ways to enforce the paper judgment. My personal point of view, Ms. Khoo.
Okay.
So, I'm talking about enforcement right now. the best way I would prefer is to go for Ganesha Proceedings against the other party. I mean, this is my personal point of view, because ultimately, at the end of the day, what we would like to is get back our money. And then the Ganesha Proceeding is against the Ganesha, which are the banks. So those are directed towards the accounts of the person who owe you money. So through these proceedings, we can serve the court papers to the bank. Then at the point of time, they have, if, let's say, giving an example, one person, party A, obtained a judgment against party B with an amount of 100,000. And then we filed the Ganesha Proceedings in the court against those banks which we believe B is using, or B is having a relationship with, or having a transaction with. And then if the court grants the order, the court papers will be served to those banks. And then if the bank discovers at the point of time when the paper is served to them, there is an amount of 100,000 with the bank, and happen to be that bank also having accounts which the B uses, the bank will earmark that money at the point of time, and then that 100,000 cannot be moved, cannot be used. So later part, lawyers will have to attend to the court again to do the proceedings, and then to get the money from the bank which is used by the party B. So I think that is the best way for me, because ultimately people want money, not any other thing. I mean, my personal point of view, Ms. Khoo, but how about you, Ms. Khoo?
Okay, as what Mr. Ng say, what is correct. Okay, assuming that today you get a judgment against the debtors, and that with the judgment, the debtors still don't want to pay to you, you actually can do a lot of matters to enforce the judgment. Okay, what Mr. Ng say is Ganesha Proceeding. So basically, Ganesha Proceeding is that without going through whether the debtors want to pay you or not. Okay, as long as you can get the information like of his process fields, bank's account, you can directly ask the court for direction to get the money from his account. This is what Mr. Ng's suggestions. Okay, my another suggestion is that, of course, is judgment debtor summons. In short, I call it as a JDS. Judgment. Okay, let me type the words judgment debtor summons. This is the method I quite prefer. Okay, I called it. I showed it. Okay, I will do this one called judgment debtor summons. Okay, judgment debtor summons is that assuming that if you get a judgment against the debtors, and the debtors still don't want to pay you the debt, right? So you can actually ask the court, you start a proceeding called judgment debtor summons, whereby the court is going to direct the debtors come to the court to make the payment. If the debtor refuses to make the payment, the court will direct the debtors to put them into jail. Put them into jail. That means that they lost their freedom. You know.
So another way also, you can make the person who owe money to malu lah.
Yes, they will go to the jail. And what if, you see, sometimes, right, when the court directed the debtors to come to the court as per this judgment debtor summons, and the debtors fails to turn up in the court, right, the court can actually issue issue arrest order, or we put in the layman term, just something like warrant of arrest. And the debtor, then the bailiff will go and arrest this debtor, go to the court, and this debtor must make the payment. If the debtor refuses to make,
when he's being arrested, then I believe he would be embarrassed then.
First, he will be embarrassed. Second thing, of course, they will be scared, you know. I tell you, if you lost your money, it's nothing. But if you lost your freedom, this is everything.
That is also one point, yeah.
That's true. Then those debtors, right, they have to pay lah. If no, they have to go to the jail.
So, Ms. Khoo, what do you think? I think you think this is a good way. I mean, to enforce a judgment against an individual. You think this is the
for
good
individual
way?
For individual, I think this is quite a good method as well. As what I just now mentioned, Mr. Ng. If you lost money, it's nothing because we can earn back the money. But once you lost the freedom, then you lost everything. You can't go to work. You have a criminal record. You have a record there. It looks so bad on you. So no matter how, you have to fork out a way to think that's the way to pay the money. But I think not everyone actually knows that this has this kind of method, you know. Everyone thinking that I sue the fella don't want to pay me the money, that's all. A lawyer cannot do anything. It's not that. It's whether you're familiar with this kind of debt recovery proceeding or not.
So how do you think about this? What is your point of view on the bankruptcy proceedings? Because a lot of people told me I want to make that fella bankrupt, I will sue that fella until bankrupt. So Ms. Khoo, do you think this is a good way after you've got a judgment to enforce this bankruptcy on the person? Do you think this is a good way, Ms. Khoo?
Okay, let me type the banner first. So can show everyone who is online whether bankruptcy is a good way or not. Okay, let me do few comparison. Let me do few comparison. You see, a lot. Okay, assuming that today you are owing money to the bank. Okay, normally the bank will have a very standard SOP. You can't pay. I give a example: housing loan installment. Okay, assuming that you can't pay the housing loan installment, the bank first thing what they are going to do, they are going to auction your property first to try to recover the debt. Yes, whether enough to recover or not. If they feel that after I auction your property, I still cannot recover the full sum of the whole debt, right? The next thing they are going to do is bankruptcy because they are doing based on SOP only. They are doing things based on SOP. In my own personal perspective or my own opinion, I don't think bankruptcy is the best way or is the good way as what you think or what the other people think. It's because what I'm going to do. Normally I will advise my client as what Mr. Ng you will advise is that first thing, try garnishing first. Try to get whatever money in the bank account first. Second thing, if you don't have the bank account, never mind, go for judgment debtor summons first. At least arrest the person and put it into jail. Definitely they will pay. If you don't want to do that, you want to straight go for bankruptcy. Okay, then here's the problems come. Assuming that you successfully put the fella into make him a bankrupt, meaning he's already bankrupt. But you don't forget that, okay, his asset, whatever asset that he has, right, first, according to the law, had to be distributed to the secure creditor first. Mr. Ng, can you tell the public who are the secure creditor?
Banks, obviously.
Of course. Second thing, have to go for unsecured creditors. Assuming that if someone owning the money to you, definitely they own a lot of money to the banks. If you go for bankruptcy, then the secure creditor will get the money first, not your turn. What for?
Then another point is that the one I like to emphasize is that Ms. Khoo, which I also concur with you, agree with you that at the end of the day, we just want the money. Why for? What for? We need to make the person bankrupt, and then we get nothing.
Correct.
We just want to get back the money to us. That's it. Correct. There's no point for us to get the person bankrupted because I don't earn a cent out of it.
Correct. And assuming that if the person went for bankrupt, basically, it means that for him it's very difficult to find a job or get a loan.
Of course. We cannot
he got no income. So how he's going to earn more money to pay you the debt? Yeah. So why not you try garnishing first or judgment debtor summons first? There's a lot of modes. I think before I jump into another topics, right, Mr. Ng, perhaps you can just now we already explained the first method is garnishing. The second method is judgment debtor summons. Of course, bankruptcy is another third method. We consider as a third method. Yes. What about Mr. Ng, can you explain to us what is writ of seizures and sales? You hold on, let me type the panel. Okay.
This is what we normally it happens always when the person, let's say, just giving an example, the person is having shop and the person is doing business and the person having goods. Okay, those goods can be sold in exchange for money. So what we normally do after attending a judgment, we apply to the court to get a writ of seizure and sale and seize the goods in the premise. So and then auction it off through a process and then get the money to cover your judgment sum. This is what we put it briefly. I believe Ms. Khoo would have more to add on this procedure.
I think I give an example. Example, if your debtor...
Easier to explain, people easier to understand. Yeah.
I'll give an example. Assuming that your debtors have a lot of have something. I make it simple. For example, your debtor have TV in the house, have coffee table. I make it simple goods, coffee table, sofa. So actually, when you get rid of seizure and sales, the court will actually hire someone called bailiff and go and seize all those things, right? And conduct an auction and sell off those things of the debtors, and whatever the proceeds of the sales is used to cover your debt.
But of course, minus all the expenses lah.
Yeah, of course, minus the expenses lah. But for example, if the debtor house got TV lah, laptops lah, iPad lah, iPhone lah, whatever items, item, computers, they will just seize and sell it and cover your proceeds. You see, this is also one of the good methods. Therefore, why we should go for bankruptcy first? Correct or not? Okay, Mr. Ng, one thing, you see.
Yeah.
Since we are talking bankruptcy just now, some clients always confuse. What are the difference between bankruptcy and winding up? People will say, hey, the company wind up already lah. The company bankrupt already lah. They used to aim.
I think there's a misconception. There's a misconception of an individual and a company.
Yes, some of my clients, they will walk in. They say, "I want to bankrupt the company. I want to bankrupt the company." I was like,
obviously, a company cannot be bankrupted. It can completely be wound up.
Yes. Okay. You see, in legal terms, only an individual can be bankrupt, but then a company we call is winding up, wound up. But basically, these two terms they share the same nature.
Yeah.
Meaning that if you wind up a company, the same thing. The first of all, the asset will go to whom first? Secure creditors, then followed by unsecured creditors. It's all like this, but just the wording used is different. So, Mr. Ng, if the debtor, assuming it's a company, will you encourage go for winding up?
I would not. I believe that would be the last resort. So if I got the judgment against the company, I wouldn't recommend my client to go for winding up first, because I don't think that is viable for a person who wants money. Because even if we wind up, at the end of the day, most probably, it's not certain, most probably, it would end up with a purple judgment. Most probably, I would say, from what I've seen so far. So basically, I believe a lot of persons, since we brought up the issue of debt recovery, I believe there's one point also I want to put it here, Miss Khoo, because how about if a person doesn't pay me rental and I want to recover rentals from the other person?
Okay, okay. That means that right now you want to recover your rental.
Yeah.
Okay, let me type the banner first, so our public or our audience today, they don't know what we are talking, because some audience, they might in the midst, join the midst.
Yeah. A lot of persons ask me this question nowadays, especially during the period of MCO.
Yeah, actually, Mr. Ng, I think I also receive a lot of call, from the owners. They will say that, look, hey, my tenant don't want to pay me lah. Especially for those who like
a few months and didn't want to answer my call, and then the premise is closed. I cannot call. I go there also, I cannot see anyone. I call, nobody want to pick. So I'm very frustrated, and I don't know what can I do next. And the key of the premise is not with me, so I cannot open the premise and go in to see what had happened to the premise, whether my properties inside there have been taken by the person or not. You see, all these things. I've got a lot of calls and inquiry nowadays pertaining to this kind of matter.
Wow. So I think, but if we got a lot of calls, means that it's good for you. Okay. So I think my answer will be, you should do a process called writ of distress. Mr. Ng, can you explain in layman terms what is writ of distress?
The writ of distress is an ex parte application filed by the landlord against the other part, the tenant, to recover the renters due to the landlord. So the process is like, we take up what properties or what immovable properties inside the premise, and we auction it off, and then we obtain monies through the auction, and then that money is used to cover the renters due. So that's a layman term how we go about. And I believe,
you see, normally my question for my owners, like for example, I still remember I've handled one case before.
Yeah.
It's because the tenant is actually like doing business of pub, like
Yeah.
bar. So whenever the owner want to go and correct the renter, the tenants just shut down, close the gate, don't want to let the owner to go in. Then later on, suddenly the tenant, right, could not locate and don't want to pay the rental. So it's the writ of distress can actually allow the owner to go in without the permission of the tenants or open the gate, because all the belongings of the tenants are inside the shop.
Okay, you see, normally what we do is when filing the writ of distress, we will ask the court to give us an order to break in with reasonable force into the premise. So, and also, if we're given that order, we can do it because all these are being done legally and with the presence of the court officers. So nothing for us to worry about. And then the court officers will have a list, They will do a listing of what things are in the premise itself, so that tenant cannot later on go and report police saying that my Lorex is being stolen or what my luxury item is being stolen. No. There's no such a thing because all these are being done legally and in the presence of the court officers.
I see.
I believe this is a very good way for the landlord to apply this method. So as I'm aware, as I'm being informed, a lot of landlords actually are not aware of this kind of method. So most of them would just say keep calling, and feel like frustrated with what happened. So a lot of people don't know.
When you say frustrated, right, I find a little bit funny is that yes, actually a lot of owners, they are frustrated, or a lot of creditors, it's not only owners, a lot of creditors, they are frustrated when the others, when they are debtors or when their tenants not paying their rentals or not paying their debts. But the problem is that when we advise the creditor or the owners to take legal actions, they always have doubts. They say, I don't want lah. It's very difficult. You want us to help you, yet you say you don't want. And you don't want to follow the advice.
You yourself doesn't want to take the initiative to do the whole thing. How could we help you then? You yourself must take the initiative to make the things right. Or perhaps just to rectify the concept in your mind. A lot of people nowadays are afraid of going to court or because of the case is dragging too long or all this. So a lot of things I think are actually misconceptions which had to be rectified.
Okay, Mr. Actually, we have, I look at the comments, right? There are actually few people, they put some question to ask. So, like, for example, I have these questions. You can have a look at the screen. So, this, I think it's a Miss Cherry Chan. She's asking, if the people own me the debt die, then how?
You could claim from the estate. Claim from the estate of the deceased.
Of course, the first thing is that you have to get the judgment lah.
Yeah, we have to get the judgment. Only we can proceed against the estate, because if the person is dead, someone will be appointed either as an administrator or as executor to take care or administer the estate. So we can bring the action against the so-called executors or the so-called administrators as well. So there's no problem about that. And then those debts needed to be paid through the estates lah. If the estates having money, so the debt ought to be paid from the estate, the money from the estate.
Okay, and we have another question from Mr. Daniel. So basically, Mr. Daniel is asking, if the father owed me money, is it possible I get the money from his son?
This is certainly not, because the person who owes you money is the father, not the son. So which both of them are different individuals. So it's not cannot do that. My answer is no.
Okay. There's one Mr. Lim. He's asking, if the debtors went overseas to run away, what should I do?
Went overseas to run away, what should I do? So I believe that's okay. In my personal point of view, the first important thing, you need to get a judgment from the court first, regardless of what. Enforce the judgment using Ganesha Proceedings against that person. But I believe that person may have account simulation. So enforce the judgment. First thing is to enforce the judgment on the person through the accounts in Malaysia. That's my first problem. But I believe, Miss Khoo, you do have something to add on this.
Okay, I think I put it that way, Mr. Lim. You see, I know that you must say that you can't foresee that whether your debtors is going to run away or not. But if you know that this fella owe you money, I mean, at the point of time, you see, what are the common behavior of the debtor is that when they cannot pay the money, right, they definitely will ask the creditor for some extension of time. Please give me more time. I will settle it for you. Please, please, please. For me, either you are going to soft-hearted and you are going to give the extension of time, or you are going to be very straightforward. No extension of time. Just pay me. If you don't pay me, I'm going to sue you. It depends on the attitude as well. So if you are being like very soft-hearted, I'll give you time, extension of time. Don't worry, I will give you another month to pay. Don't worry, give you another to pay. Indirectly, you actually create a chance for those creditors or for those debtors to run away. So before run away,
I believe there's a time.
Later on you run after the debtor runs away. Then only you go to our office and you cry to the lawyer. The debtor runs away. You see, that's why I always emphasize on, if you know the debtors owe you money, please take the action as soon as possible. You see,
but that's the time when a lot of people are losing money because they keep letting the people drag, and then the person ending up nowhere and then couldn't be located, couldn't be found. And when they check the immigration department, they only then finds out the person has gone overseas. Since when? So
correct.
Absconded.
Correct. And there's another audience that Mr. Harry Ng, he's asking if the company bankrupted, any method I can get the money which they owe me. I think I answer first, Mr. Ng, before you answer. As I said just now, you see, he used the word bankrupt. Actually, company is not bankrupt, it's winding up. Okay, it's not bankrupt. Okay, he said any method I can get the money which they owe me. Okay, Mr. Ng, I let you answer first lah.
No, you first. You proceed first.
Okay, I put it that way. Okay, assuming a company wound up, is there any methods that I can get the money whereby they own me? Okay, first of all, normally when a company wound up, right, a lot of clients are going to ask me, can I do something against the director in personal basis? I mean, like, since the company already wound up, I can't do anything. What? Can I just sue the director, sue the shareholders? These are the common questions they ask me. I'm going to ask one question only. Is there any document? Is there a document called personal guarantee signed between the directors or the shareholders with your company? If you have this document, my answer is yes. You can actually initiate actions against the director in a personal basis, against the person who signed the personal guarantee. If not, right, it's very difficult. It's very difficult. That's why just now what Mr. Ng said and what I said also, before you file a winding up suit against the company, there are lots of matters can recover your debt.
There are a lot of alternatives. Yeah.
Yes. So you not necessarily have to initiate a winding up suit against the company in the first place. There are a lot of methods. But unfortunately is that we also some client actually says they've been advised like file a winding up. Actually, there are a lot of methods. I don't want to comment here, but really there's a lot of methods can do it. You don't need to go to the last resort, because winding up, to be honest, is the last resort. If we want to claim the debt against them, it's the last resort.
My personal point of view that helping client to resist winding up application is okay, is alright for me, but advising client to go by way of winding up proceedings against debtor, for me, I don't think that is viable. I don't think that is good.
Correct.
My personal point of view.
Of course, if after producing all the documents provided by the clients, sometimes we will advise the client go for winding up also, but we will justify why we advise in such a way. But if after we look at the document, we don't think if this is a suitable way, I think the client have to understand, because we will provide a lot of alternatives, but it's up to the client if they want to follow or not. Correct or not?
That's a means of, if we were to advise client to go by way of proceeding, I believe there's a means of doing something. So maybe perhaps the company couldn't lose, the company couldn't let itself to be wound up. So this is the time where normally I would ask client to go by way of running proceedings because the company got more to lose if they were to be wound up.
Correct. Okay, there's a question from Mr. Andy. Can the people guarantor for me get sued as well if I own other people money?
Can the people guarantor for me get sued as well? I think if this applies, if the guarantee document is signed, I believe so. But this normally happens in the bank documents, loan documents by the bank. Normally, it's like when the company taking a loan, the company would require all the directors to sign the personal guarantee. In the event that the company not being able to pay, so action can also be taken not only to the company but also against the directors of the company. So as another way to at least to secure the payment.
Correct. That means that if you become a guarantor for someone, and the someone or the debtors refuse to make the payment, yes, you will get sued as well. You will get sued as well.
Yeah.
And this is also, for my perspective, this is also the tips when you are doing business with the company, and you know that company is a separate legal identities in the law, and you want to get the directors or you want to get the shareholders get involved so they don't run away whenever there's a debt incurs. Also, when doing the business time, why not you engage a lawyer to draft a document called personal guarantees?
And ask them to sign it.
Yes. But of course, the client feedback will be this: if we do this, I don't think the company don't want to do business with me.
Yeah, this is a problem nowadays. I also came across a lot of this. If I were to do this, I don't think a company's director would want to have business with me anymore in the future. So
correct.
This is that normally happens.
But we always will tell clients, either you be firm at your stand, or sooner or later you are going to face the consequence.
And I agree with you. I agree with you, Ms. Su. I think this is a matter of dollar and cents. We must be extremely cautious about it. So
yes,
you sign the documents or no, we don't do business because I don't want any further problems in the future that you do not pay me money and I couldn't do anything.
Correct.
So I wouldn't make myself having troubles in the future. I would rather make myself having troubles right now. So this is my personal point of view.
You know, when you want to do a business with someone, please be firm with your principle, be firm with your stand. If you just look at if I make this document, the company don't want to do business with me, I'm going to lose the profit. Then how? But you not even think that whether is there a profit or not, or you confirm that you will get the profit or you will get the money. Do whatever document to safeguard your rights.
Some people just say, okay, I got a $1 million project. The profit margin is more than 20% or 30%. So if I were to ask the director of the other company to sign this, maybe they wouldn't give this project to me. So maybe they wouldn't cooperate with me. But bear in mind that what happens if the other party doesn't pay you? Then all the materials you purchase for that project, you're gonna pay it yourself first. You're gonna purchase all the material first in order to carry out the projects, and ended up you got nothing. You got your workers to pay a lot of things for you to pay, and then what happens then? You couldn't do anything against the companies. Not mentioning the director.
Yeah, Wei Seng, I do agree with you. So sorry to interrupt you, Mr. while you missed the talking, because I think Miss Khoo, she actually comment quite a lot of the question here. So this is the question she asked: how many letters of demand before judgment debtor summons? I think he say have to be insurance. So, Mr. Can you answer to this question?
I believe one would be sufficient. I believe one letter of demand would be sufficient, and then thereafter we could proceed for the civil suit against the person in the court.
Oh yeah, I have to stop in the middle. I forget to emphasize on one thing. For those who are interested in this topic, debt recovery, we have set up a Google form for you guys to fill it out. Okay, in the Google, after you fill out the Google form, I'm going to send you guys a free journal, whereby this free journal is basically talking about the debt recovery proceeding. What basically is written by me, so you can have a look what you should do and learn some basic legal knowledge I do it for you guys. So if those are interested to get a free copy of journal, please fill in the details in the Google form shown in the comments box. Okay. So I think there's a question from Kelly. Kelly is asking, for my experience, I tried to request the amount of debt via letter of demand issued under my personal capacity supported with bank in slip, and WhatsApp message proof. However, I was challenged that the letter of demand should be issued by the lawyer. So, Mr. Ng, what is your comment?
I don't think there is such a requirement that ought to be issued by lawyer. But the point is, the important point is that, have you brought any legal action against the other party in the court? I think that should be the point that we should emphasize here. Because if no legal action is taken, from my point of view, in the shoes of the other party, they wouldn't be, nothing happened. Just a letter. The most important thing, you need to bring legal action. I believe that's the point. No legal action, I think most of the time nothing would happen.
Okay, my answers to Kelly is that, you see, it's not wrong that if you want to issue a letter of demand through your personal capacity, but the problem is that you say you are challenged by the lawyer, says that the letter of demand should be issued by the lawyer. I'm not sure how you draft I'm not sure what are the format or what are the style that you are drafting the letter of demands, because as a we like Mr. and I, we are practicing lawyers, so we know that how to draft a proper letter of demand. So I'm not sure how you draft it. That's why you got challenged by the lawyer.
Yeah,
so
maybe yeah.
You know, because letter of demand is not like you writing an essay or you narrate your story. It's not in that way. But we will have not a specific format, but when you must have some key terms or keywords.
Exactly.
That's the skill of drafting lah. I don't know how to explain. Okay. We have another question from Khoo. Can sue director for bankruptcy?
No, why they want to mix up director and with bankruptcy?
I think what this Miss Khoo she's trying to say is that, looks, assuming a company is bound up, then can sue the director for bankruptcy.
Company is bound up, can they sue the director for bankruptcy? Yeah, I don't see a point of getting a director to be bankrupted. And at the end of the day, what do you get?
I think I point that way is if the debt is owned by the company, you can't take any action against the director in a personal capacity or against their personal
unless
basis.
Their personal guarantees signed, or you leave the will. Yeah.
And she also comment, can take key and lock the premise. I guess because this is not a question, more like a comment, So I guess what she's trying to say is that
that was related to our question of
rental.
Yeah.
Yes. So I think maybe is she trying to say is that without the court order, can you just take the key and lock the premise?
I don't think that's advisable. Anything happens if someone is inside there and the person having some problems or whatever happens to the person because unable to come out from the premise, that would be having legal implications on the person who locked the premise. Also, don't ever do that. Don't ever do that, please.
Yes. Okay. Another this one I just not overlooked. Jordan actually asked the questions. How about claim money through SIPA? Can you explain? Wow, Jordan.
In school, I think you are more proper and more experienced to explain this.
Thank you, Jordan, for asking this question. If you're asking this question, means that you're from construction line. It's because normally in construction line, when the debtor not capable to pay the money, we will in short it's not actually not through SIPA. SIPA is a statute, is a law, but normally we will say it's like by way of adjudication. But in those who are involved in construction line, they tend to use the word SIPA. So for those in construction line, yes, if you want to claim the money, normally we will do by way of adjudication, or in layman term, you say SIPA, then I follow you say SIPA. Okay, but you have to make sure few documents, you have to get ready few documents. For example, where is your CPC, or what is your PAC, your certificates of practical completions to show that your work has been done and verified and approved. And with those things, right, yes, we can do adjudication for you, no problem. And it's a very quick and fast process. And the judgment will be recognized by the court as well. So no problem, you can do it. I think for this topic, right, I will make it next time on the next topic, because this one need a very detailed discussions Not today, because today we are just to discuss debt recovery. Okay.
I believe that requires a lot of explanation and a lot of things to talk about, I believe, Ms. Khoo. I mean, that's a huge topic, I believe.
Yes, correct. I think I'm going, because right now almost 9 p.m. I'm going to just show the last, pick up the last questions asked. Is Miss Khoo is asking if winding up can sell out their company stock.
Stock meaning?
I think company stock, I think it means the good remaining in the company. I guess. Yeah, Mr. Ng, any comments?
I believe, okay, it's doable.
Okay, my comment is that, you see, whenever a company went walk up, there's one fella or one, I use the word fella. Okay, there's one man or there's one fella called liquidator is going to manage the assets of the company. Of course, if the company have stock, right, they will sell it and get the money and to pay to the creditors. But as what I keep on repeating, the first one who they are going to pay, secure creditor. Who are the secure creditor is the bank. Then follow is unsecured creditors. So just make sure that you're in the rank lah. You know what to do. Okay. So if you I think I have to end 9 p.m. I have to end around because now it's 9 p.m. Actually, basically today.
Let's call it the day.
Yes, let's call it the day because today basically I'm very tired. I'm very, very tired because today whole day I have a full meetings and then I have to answer a lot of calls, drafting a lot of court papers. So basically I'm very tired today. But last but not least, for those who are interested to get a free journal, and this free journal is basically talking about debt recovery, please fill in your details in the Google form shown in the comments box and we are going to email a copy of free journal to you guys. And this free journal is written by me. Look, I'm the one who written. So if you're interested, then you just fill in, we will send it free for you. And for those, if you have questions about debt recovery and you would like to have consultation, of course, we have already published our full firm name, our phone numbers, and our office number. You're free to make any appointments. And you can call Mr. Ng for appointment for consultation for anything that you want. Okay, Mr. Ng, is there anything else you want to say before we call it off a day?
I'm still emphasizing on the same thing. If you have people who owe you money, please recover it sooner as possible. Do it ASAP, don't do it. And then don't keep it dragging. Especially nowadays, this is a time where a lot of people owe money and a lot of businesses are having problems. Please do it soon as possible. If you still want to get your money, do it soon as possible and do not wait.
Yes. I think right. Okay, this is the please fill in your details in the Google form. You're going to get a free journal. Okay, I think last but not least, this is my experience. Even though I'm very tired right now. Okay, normally when you know what are the main cause that the creditors they cannot recover their debt is because one thing only. It's not about legal things. It's about they are very soft-hearted, too soft-hearted, and not dare to take any legal actions. For me, attention to all creditors. Okay, when the debtor own you the money and they refuse to pay as what they have promised, means that they are wrong. They are totally wrong in law. Okay, so it's really you have a right to claim your debt back from the debtors. But one thing is that if you refuse to take action, we really can't help you because no matter how, we as a lawyer, what we can do is that advise the client. But we can't force the client to do anything without the permission from the client.
Absolutely correct.
Please, if you want to recover your debt, not to be soft-hearted, because from my experience, a lot of creditors, they are too soft-hearted until they're not there to take any action against the debtors. Eventually, because of the debtors, the creditors or the boss, they lost their business because they cannot have the money. They lost their business, and then some of them, the worst thing is that some of them, right, they go and get some stock from the other fella to sell it to the debtor, and then indirectly they become the debtor as well. So what for? What for? If you have a client who cannot pay you, or you have a debtor who cannot pay you, they are not a good client. They are not a good client. They are considered a bad client. You know, it's not a good client. You must take actions. Yes, don't try to have that kind of thinking that, looks, if I sue them in the future, I don't think they will work with me. They will get stock for me or they will buy stock for me. You should throw away that kind of mindset, because a lot of my clients, they have this kind of mindset. It's totally wrong. Until the time right, they cannot recover their debt, and at the same time they owe people a lot of money. They are suffer. They only look for us.
Yeah.
This is really, really wrong. Okay, Miss Ng, anything else?
I think that would be all for today.
Yeah. For those who are still online right now, okay, for the next topic, right, we are going to talk about something about debt recovery as well, but we might like talk about something more specific. Maybe we will like really go into some proceeding, like what Mr. Ng say, maybe Ganesha, our JDS judgment debtor summons. We will go into very details. Like from time to time, please, because I know we are making announcement in a very rushing manner, but we are trying to adjust it, like not to make the announcement in rushing manner, just like, but from time to time, if we create an event, if you are interested, please click the button interested, so we know that you are interested in this topic, and we will focus more the topic. Or if you want us to talk the other topic, those topics where you are interested in, you will always can comment in our Facebook. Then we will prepare the relevant topic that you are interested in. Okay. Time. So say goodbye. Bye.
Yeah, bye everyone. Bye everyone.
Bye. I haven't had my dinner yet, so I'm going to have my dinner right now. See you guys.